to the 30th and 31st annual reports on monitoring the application of EU law. The floor goes to the rapporteur, Mr. Chrysogonos.
Thank you, Chairman. First of all, I would like to thank all committee members who tabled 60 amendments to my draft report on monitoring the application and implementation of EU law during the years 2012 and 2013. This is evidence of how interesting the topic is and illustrates that we can increase the impact of the work of our committee by submitting a comprehensive report which, although in line with previous years' reports on the same issue, will, however, have some new elements and hopefully take a wider perspective on the issue under examination. I have already examined all your amendments. I have seen that some of them are pointing to the direction of improving the ideas included in the draft report, some aim to oppose what is suggested in the draft report, and some introduce new perspectives which were not incorporated in the draft. Of course, we cannot agree on all issues, but I am sure that for most of the proposed amendments we can negotiate and find some common ground. I have already started working on compromise amendments, but of course I want to hear your position here in the committee and thus have the chance to discuss directly with you your ideas and proposals. In this manner, we will all be able to understand better how we should perceive issues under examination and how I can work efficiently on presenting to you a bundle of compromise amendments which can subsequently be discussed in more depth and detail in a meeting of the shadow rapporteurs. As a final remark, let me say that the quintessence of my draft is an effort that light be shed upon some possibly discomforting facts. Those are, first, that there is a distinction between primary and secondary EU law, and that the Charter of Fundamental Rights is a part of the superseding primary law. Second fact is that it is conceivable that non-application of EU law may come not only from institutions of member states, but also from European institutions, in the form of violation of primary law and especially fundamental rights through their behaviour. Third fact is that austerity policies which have been implemented during the last 5 or 6 years in order to face the economic crisis, especially within the Eurozone, put severe limitations in particular upon social and economic rights enshrined in the Charter of Fundamental Rights. This is already described, for example, in the very detailed and thorough study for the Directorate General for Internal Policies of the European Parliament concerning the impact of the crisis on fundamental rights, which has been published some weeks ago upon the request of the LIBE Committee of this Parliament and which is mentioned in my draft report. My point of view is that a report concerning the application of EU law during the crisis years, such as 2012 and 2013, has at least to deal with these problems in order to be somewhat convincing for the European citizens who may read it. Of course, if the majority so wishes, this committee and finally the plenary session of the European Parliament could simply disregard these facts and delete any reference to austerity, to social rights and to their problematic relationship. This, however, would not solve the existing problems. It would rather indicate that this Parliament can neither accept realities nor try to address them in a way that may help the further advance of the European integration process based foremost upon respect for human rights. Thank you.
Thank you as well.